A fantastic idea. I'm happy to do it. First, if you haven't watched my 3-part recap of yesterday's Rule 62 hearing, where the judge did set a $40,000 bond in order for Brenay to secure a stay or a pause on the collection of the judgment against her, please feel free to check that out. It was very informative. This video is just a Q&A, so please make sure that you check out that recap if you want in-depth details, because you might be missing context. Before we begin, I am a certified law nerd, bona fide non-attorney. This is not legal advice. This is just me sharing what I've seen, heard, read, and most importantly, researched. Are you sick of hearing me say that? Good. I am not sick of saying it because that's what CYA's my CYA. It covers my ass, okay? With that, let's begin. First question, when is she going to pay the $40,000? I need to clear something up right away because this is circulating on the internet. Brenay is not paying Akira $40,000 right now. Brenay has a bond set for $40,000. That $40,000 goes to the court while the appeal is pending. I just needed to burst your bubble there because I think people are expecting Brenay to hand over a check for $40,000 to Akira, and that's not how this works. Not yet, at least. That is due as soon as possible because the clock is ticking. See, this judgment is still very much active. In order to get the stay, she has to produce the bond that has just been set. No bond, no stay. What is a stay? It is a pause. She is asking the court to pause collection efforts while her appeal is pending. The court is saying, okay, I can only do that if you produce this bond. There is no statute that cleanly states how long she has. Typically, it needs to be as soon as possible. So she may have a few days, a few weeks. All the while, technically on paper, Akira can still pursue collection. Will she do that? No, we most likely won't see that because the court has already indicated that a stay can happen with the bond, and Akira has agreed to that. She's the one that requested the $40,000, and that is what the court granted. Now, I don't see this stretching out beyond like 30 days, obviously, because the judgment is active. And let's say, theoretically, I am not inserting this, I am not accusing anybody of anything, but I am presenting this theoretical scenario. Let's say that this is being used as a delay tactic. It would backfire royally because, again, the collection is still active. I don't see that that's what's happening. They're asking for an official pause. And so we should expect to see that within the next few days, maybe a few weeks, tops. How will we know when that happened? Because we will most likely see either a follow-up hearing, I don't know if that's going to happen, or we'll see the judge's order. So if the bond is produced, the judge will enter the order granting the stay. I'm also going to say this way. Because that $40,000 is collateral, should the appeal fail, Akira immediately receives those $40,000 and then gets to continue collecting on her judgment. That's how that works. If the appeal is granted, those $40,000 go back to Brenay because obviously something else needs to take place now that the appeals court has ruled in her favor. So it really just depends on the outcome of the appeal. If the appeal fails and she gets the $40,000, does Akira get to continue collecting her judgment? Absolutely. That's what that bond was for, to make up for lost time, if you will. It's there to protect the creditor, who is Akira, because she is about to lose time in collecting on that judgment while Brenay is appealing. Another question I'm seeing is whether she gets to appeal if she's not able to produce the $40,000, or what happens if she doesn't have the $40,000. Her appeal is already in process. Nothing is stopping that. Attorney Fairman is already working on that. However, if she cannot produce $40,000, there is no pause. So while the appeal is happening, Akira can absolutely file another writ of execution and still continue to collect. But no, that does not mean that if she doesn't have the 40 grand, she can't appeal. Appeal is still happening. This is all about pausing. Another question, when will we know if the appeal has been denied or granted? It takes time. Appeals can take from 9 to 18 months. Realistically, in this case, it'll probably be more like 9 to 12 months, unless the appeal is denied on technicality. I don't know what's going to happen there. But this is already underway. We should see an appellate briefing pretty soon from Attorney Fairman. We should see a response from Attorney Robin, and then that's going to go up to the appeals court. But that takes time. Another question. When the judge said at the end, if you don't know what I'm talking about, go back and watch the recap. At the end of the judge's ruling, before he adjourned, he said, just stop. People want to know what I think the interpretation of that is. I will say on the internet, I've seen different interpretations of it. I've read some articles where there are some interpretations of it. I tend to agree a little bit, but I feel like it's a little more involved. Judge Tessner was the presiding judge over the preliminary motions when the alienation of affection lawsuit began. Judge Wilson is the one that took over and presided over the trial itself. So it is not lost on me that he has been a part of this way back when, right? So this started back in 2024. That's a lot. That's a long time to be in court over the same issue. So seeing it at this tail end, I'm going to be honest, it just felt like this was beyond legal argument. I think he was saying, just stop. In other words, stop using the courtroom like a boxing ring. That's how I took it. I'm speculating. I'm not a mind reader, so I don't know what the judge did not explicitly, he did not elaborate on what he meant, so I am speculating on what he meant. But that is what I feel he was saying. And my final thought, somebody specifically asked me what I thought about Brenay's counsel speaking on just the media attention in the court that we're getting, and just how much of a media circus this has turned into, even for something like a procedural hearing. And I can understand that perspective to an extent. However, it does feel a little double-edged when in the hearing we're attacking the plaintiff and this is a procedural hearing. So Brenay's on the stand calling Akira a liar and accusing her of calling the media and accusing her of weaponizing social media. Meanwhile, I have personally witnessed Brenay do just the same, weaponize social media, that is. And it was just funny. It just felt a little funny hearing that perspective, given the testimony that I heard in court. The testimony in court stretched way beyond just procedural. So, I don't know. But those are just my 2 cents. I'm nobody. I'm just a nobody on the internet. And you know what? Naturally, people are going to pay attention. This is all over. The major media outlets were there with their cameras, with their laptops, with their notebooks, with doing interviews. So, I don't know. It is what it is. We are just here exercising our rights and enjoying the storyline, which hopefully will leave the courtroom soon, because God. Those are the major questions. If you have anything else, I'm happy to answer them. And if not, I'll catch you in the next video.